For those just entering the webinar, I'm going to wait a moment or two to allow others to join, and then I'll proceed with introductions. Hello, everyone, and thank you so much for joining us this morning, afternoon, or evening, depending on your location. My name is Nicholas Stephanopoulos, and I'm the Kirkland and Ellis Professor of Law at Harvard Law School. Today's discussion is being hosted by the Ash Center for Democratic Governance and Innovation at Harvard Kennedy School, and also co-sponsored by the Equal Democracy Project at Harvard Law School. I want to start with a few announcements on the Ash Center's behalf. The Ash Center would like to acknowledge the land on which Harvard sits as a traditional territory of the Massachusetts people and a place that has long served as a site of meeting and exchange among nations. Today's event is being recorded, and the video will be made publicly available on the Ash Center YouTube channel. You are all welcome to submit questions anytime throughout the duration of the event. Please send them via the Q&A button at the bottom of your screen, instead of submitting them via the chat. Now I'd like to briefly introduce the panel joining me for today's conversation, titled The State of Redistricting and the 2022 Elections. Mitchell Brown is counsel for voting rights at the Southern Coalition for Social Justice. He graduated from the New York University School of Law in 2017, where he served as the chair of the Black Allied Law Students Association. Mitchell also graduated from North Carolina A&T State University in 2012, earning a BS in business economics and a minor in philosophy. Kathy Duval is a managing consultant for fair representation in redistricting. Her focus is to build a more collaborative funding space on a range of redistricting projects, strengthen existing coalitions, and provide strategic advice to state redistricting efforts. She is working with state and national organizations to define strategies, to identify opportunities and gaps for redistricting reform efforts and litigation, to secure data and technical support, and to build out the broad engagement necessary to create more fair representation in the 2021 redistricting cycle. Colleen Mathis is the former chair of the Arizona Independent Redistricting Commission. As a registered independent from Pima County, she was unanimously chosen as chair of the commission by the 4 appointed commissioners. Colleen earned a master's degree in environmental management from Yale University and a bachelor's degree in economics from the University of Illinois. She now works for Caterpillar as a demand consultant for large mining trucks. And Benjamin Schneer is an assistant professor of public policy at the Harvard Kennedy School. His research is in American politics and focuses primarily on political representation, how citizens express their preferences, how government responds to them, and what may shape and distort these processes. He has also worked with computer algorithms for redistricting and carried out analyses of racial polarization in voting for purposes of Voting Rights Act compliance. I'd like to begin by discussing redistricting commissions, which are the multi-member bodies that design districts instead of sitting politicians in a growing number of states. To a casual observer of the redistricting process, the recent news about commissions might seem mixed. Some commissions, like in Arizona, California, and Michigan, seem to be doing quite a good job, producing fair maps without much internal disagreement. On the other hand, other commissions, like in Ohio and Virginia, have drawn maps that are accused of being flagrant gerrymanders or have failed to draw maps at all. Colleen, let me start with you. What explains this good news, bad news dynamic with commissions? Does it tell us anything about how commissions could be revised in the future to be made more effective?
I think it does. So first of all, thank you so much to Harvard Kennedy School and Harvard Law School today for sponsoring this panel. I'm delighted to be a part of it. And yes, having served on the Independent Redistricting Commission, I can speak from experience in this regard. I would say the success of a given commission is going to be rooted in how it was composed initially. And in Arizona's case, it was rooted, the proposition that citizens voted on to pass independent redistricting and bring it to our state in 2000 was rooted in tripartisanship. A Republican, a Democrat, and an independent got together and drafted the language and got help from League of Women Voters and Common Cause to essentially come up with language that voters would then vote upon, and it passed with 56% of the vote. And I do think that that kernel at the beginning was really important in terms of how our commission was designed. And also I will say I am biased. I am an unabashed fan of independent redistricting. It comes in many forms and stripes, though, and as Nick pointed out, there's differences, and some states are succeeding right now and some have had a lot of challenges. And I think often that gets down to who is on the panel, because in some of those states mentioned, for instance, Virginia, sitting legislators can actually serve on the commission. In Arizona, it's 5 total people. They're all citizen volunteers, but 4 of those 5 are appointed by majority and minority leadership by the Arizona legislature. So some have said, well, then you're not truly independent. And I take that critique, but that is how it was designed. I'd still say, though, we're better than the legislators drawing it themselves. The legislature has no say. They cannot reject our maps. The citizen panel in Arizona is very powerful when it comes to redistricting. It can't be vetoed by sitting legislatures. So that gives you a little bit of flavor. They're all different across the country. So I hope that answers it. And I'm happy to go deeper if needed.
Thanks, Colleen. Kathy, you're involved in redistricting reform efforts across the country. One of these efforts is at the federal level, where the US House passed a bill earlier this year that would require states to use commissions for congressional redistricting. What do you think about this federal proposal? Do you think federal action is the way to go here?
Thanks, Nick. And I also want to echo Colleen's thanks to the law school and to the Ash Center for sponsoring this panel. Yeah, I think that the House has the opportunity to pass the Freedom to Vote Act, and it covers a number of voting, redistricting, and money and politics issues. And the redistricting piece of that is quite robust. I think of there are 4 key components to fair maps. The first is who draws the line, and Colleen made a great, case for why independent commissions are super important in that. The legislation would require an independent commission by 2030. The ship has left the harbor for this cycle, and so we're not likely to have independent commissions now, right? But sort of figuring out how to get the politicians out of it is a key component of it. The second component is what criteria are used to draw the line. So that's banning partisan gerrymandering or validating coalition districts, limiting county and city splits, prioritizing communities of interest. And both the House and Senate versions of the Freedom to Vote Act have strong provisions to ban the partisan gerrymandering. The third component really is the process for remediation, and we'll get into that when we talk about the loss of Section 5 of the Voting Rights Act, but that the bill includes a process that attempts to clarify the legal process and allows for the courts to impose maps and not have to have us wait the years it often takes to resolve some of the lawsuits. And then finally, there's the issue of protecting communities of color and the implementation of the Voting Rights Act and the freedom. There's an adjacent bill, which is the John Lewis Voting Rights Authorization Act, and it covers more of that than the Freedom to Vote Act. But all of these components are going to be super helpful, and they're kind of incomplete without each other. But given the challenges that many states are having to secure fair maps, even with commissions, in particular, I think with these sort of bipartisan commissions, that federal legislation would be very helpful. I am a little skeptical that we're going to get it this year, but it's totally a fight worth having.
Thanks, Kathy. Ben, You've previously done work for both the Arizona and the Virginia redistricting commissions. Can you describe that work and maybe more generally tell us what role do political scientists like you play in assisting commissions with their work?
Sure. Thanks, Nick. And like both Kathy and Colleen, I just wanted to say thank you to the Ash Center and the law school for hosting this great event. So I think political scientists have a few different roles to play in assisting commissions. Probably the most common one is helping to analyze elections data to try to understand past and likely future electoral behavior in the state, particularly as it pertains to compliance with the Voting Rights Act. And that's also the role that I'm sort of most familiar with. So I can give an example from working with the Arizona Commission and Colleen in the previous cycle that maybe gives a bit of a flavor for what a political scientist might do in that role. So at the time, and this isn't any longer the case, Arizona was subject to Section 5 of the VRA. And so there was a lot of concern about meeting the standards for pre-clearance for both the congressional and legislative maps. And so a key question was whether the new maps produced by the commission showed evidence of retrogression, meaning did the new maps make minority voters worse off than they were under the previous maps or not? And so to make sort of like precise, supportable claims in response to a question like that is actually not that straightforward. You have to sort of understand which candidates have been supported by different groups in the state in the past and who is likely to be preferred in the future. Who will be the candidates of choice. And so that involves a considerable amount of analyzing past elections data, which is kind of where the political scientist might come in. And so that is tricky also because we have a secret ballot and you can't directly observe how different groups are voting in a given district. And so in the role of the analyst or the political scientist helping the commission, you would do something like an ecological inference analysis where you would look at how precinct level vote totals are varying in conjunction with sort of the demographic composition of the district or of the precinct to try to make a projection, to sort of try to characterize the voting behavior of these different groups. And so, ultimately what you're trying to do is figure out which racial groups prefer different candidates and do they have the ability to elect those candidates. And so now with Section 2, the concerns are slightly different, but again, the political scientist is still sort of in the same role of analyzing elections data to figure out which are the candidates of choice in the past, who are likely to be the candidates of choice in the future, and whether a given map is able to perform and in that regard. I think another role that I personally haven't been involved in, but that I know some political scientists are involved with is in the drawing of maps itself, right? So how do you go about drawing the district maps? And so you have someone like Nate Persily at Stanford Law School, who's an election law expert and a law professor, but also a political scientist, who's sort of one of the go-to people when it comes to map drawing, and I think was helping the Maryland Citizens Commission drawing their maps. And then in Virginia, where the commission ultimately wasn't able to agree on a map, you have another political scientist like Bernie Groffman, who's been appointed by a panel of judges to sort of step in and produce a map. So that's one other area where political scientists might serve as an expert in this process.
Great, thanks, Ben. Mitchell is the only lawyer on the panel. Let me ask you about the legal challenges that commissions face. So what do you think about the argument that commissions for congressional redistricting, when they're adopted by states over the objection of the state legislature, unconstitutionally infringe the state legislature's authority? And I guess relatedly, do you think Congress has the power to mandate the use of commissions across the country?
Thank you for your question, and I echo the thanks to Harvard Law and the Ash Center for having me here. My first thought is that I don't think this argument that if the citizens of a state want to create a districting commission such as the one they did in Arizona, I don't think that the legislature has a leg to stand on if that is what the citizens of Arizona want. and they've gone through the correct referendum process to put that on to all the voters in Arizona. I don't think the legislature has a leg to stand on. And additionally, because the citizens are the ones that put the legislators into the legislature in the first place, that power resides with the people. And if that's what the citizens of Arizona want, then that is what is necessary. I don't think that's unconstitutional because it's set out under the state constitution. One thing I do want to note on that point is too often what we're seeing now is that legislatures are drawing districts and choosing the voters in which they want to represent. Commissions offer us an opportunity to have a third party draw these districts based on statistical evidence and other nonpartisan type redistricting principles to draw maps that are more equitable than what the legislature would draw. In North Carolina, there was a case, Common Cause v. Lewis, where the North Carolina court struck down North Carolina's redistricting maps because it was an extreme partisan gerrymander. The court specifically noted that the legislators were choosing their voters, not the other way around, and that was a fundamental flaw and went against the Republican notion of government. And so that is why commissions are important. And then to the point about Congress having the authority to mandate commissions for congressional redistricting, there's a case called v. Jubileer, in which the court noted that under the Elections Clause, the Congress had the authority to change the way districts were drawn by the states, and so extending that a bit further, it's not far-fetched that Congress could mandate congressional commissions, and I think that would create more equitable maps, and it would be completely legal.
Thanks, Mitchell. Let's turn next to some of the data and methods used in redistricting. So of course, this is a field with huge implications for representation and democracy, but it's also the most quantitative and technical area of election law. And so data and methods really do take center stage. Kathy, you've been a leader in making redistricting data publicly available and also in helping to create new kinds of data. For example, for identifying communities of interest. Can you talk about these data projects of yours and why they're important?
Yes, thanks for the question. As advocates across the country looked at what could be done to help produce fair maps, one of the challenges they identified is that politicians and party hacks and that sort of insider track had access to sophisticated data to be able to draw and analyze maps, while community activists, maybe even civil rights lawyers, journalists, academics, they were all at a disadvantage and competing on that uneven playing field. So we really came out of that with the idea of creating a redistricting data hub, which is found at redistrictingdatahub.org. Let's see if I can drop that into the chat. And with the goal of really democratizing that data so that to allow anyone and everybody access to this sophisticated data sets. So to draw and analyze maps, you obviously need the updated Census Bureau redistricting files, but you also need disaggregated American Community Survey data. You need election results. You need precinct shape files that have been tabulated to connect with the current census blocks. And it's hugely helpful to have voter file information or incumbent addresses or in education and income levels. So working with a number of other academics, there was a lot of people who sort of was like, hey, let's figure out how to make some of this available. And so working with the folks at the Princeton Gerrymandering Project, MGGG Redistricting Project, the Florida Voter Education and Science Team, Charles Stewart's MIT's Election Data and Science Lab, we compiled all of that data into a single place, standardized it, and then made it publicly available on the Data Hub's website. They've launched also an aggressive training program then to teach people how to use the data, like what's this data for, and then how do you incorporate it into the free mapping tools that were out there so that organizations and individuals could be able to access the data, they could map their community and be able to identify that as a community of interest and actually submit that. And then they could analyze the maps as proposed maps were coming out to be able to better produce feedback. To date, the data hubs uploaded approximately 12,000 individual data sets, and it's really allowed these community organizations to be able to engage in a much more technical way, which we kind of know and believe that input will be better than sort of a vague description of what their community is and why something might or might not be, is sort of representative of their community. The RDH is now involved in the process of gathering up much of the community of interest submitted testimony across the country, as well as final approved maps, to create a historical library of this decade's redistricting cycle. And we hope this, among other things, will allow us to actually kind of evaluate and have a better sense looking back about what worked, what didn't work, how do we do it better, to be thinking forward then to what's going to happen in 2030. And there are two other things then to note. First, the Data Hub is replicating the data set on the Harvard Dataverse for long-term accessibility. While I think the Data Hub's website is a little bit more user-friendly than the Dataverse, Harvard probably wins on longevity. So having it in both places, I think, is good. Second, the Redistricting Data Hub is also exploring how their expertise in spatial data sets could be useful for other democratic analysis. So on voting rights cases or civic engagement or public engagement effectiveness. So if any of you all have ideas along those lines, please let me know. And the real goal in all of this is ensuring that part of the public participation in redistricting is ensuring that they have the tools to be able to, sort of adequately and articulate their community interests in a way that it can best be incorporated into proposed and ultimately adopted maps.
Great, thanks, Kathy. Ben, you've done work with redistricting algorithms that quickly spit out large numbers of district maps satisfying whatever criteria the user specifies. Can you talk a bit about the applications of this algorithmic tool in litigation and district drawing?
Sure, but before I get to that, I just wanted to say that as somebody using redistricting data, I can just attest to how much of a leap forward we've seen this redistricting cycle as compared to 10 years ago in terms of just how available all the data is. And I think a lot of that is due to the work that Kathy and the other folks she mentioned have put into making all of this available. And I think one element of that is just that it does, I've seen it makes it so much easier for anyone to download this data and to scrutinize it. And it's really like night and day. 10 years ago, if you were interested in some states, you would literally have to sort of pester people at the Secretary of State's office or other people at even county level offices to get a hold of precinct level election data. And that's really no longer the case anymore. So it's a huge leap forward. So with respect to the redistricting algorithms, generally what these algorithms are doing is subject to some set of pre-specified constraints, like say population equality across districts or compactness, producing a target distribution of sort of generated maps for a given state or geographic area. And so what does that actually get you? Well, one of the key uses for this approach, which some people call an ensemble method, is basically as a point of comparison to try to assess the partisan fairness of a given map that has maybe even been produced by a state legislature or a commission or any map really. And so if you're generating a bunch of maps without taking partisanship into account, you sort of get a sense of the distribution of possible maps in a state, right? And that can vary state to state depending just on the geographic sort of dispersal of voters and in terms of just the types of different maps you're likely to get. And so if you do that, if you run these algorithms to generate a target distribution of maps, not taking into account partisanship in drawing the lines, and then compare a map that was, say, produced by a state legislature, and if it turns out that map is, say, advantages the party in the legislature more than 99% of all the other maps generated in this target distribution that isn't taking partisanship into account, you can say with a pretty high degree of confidence that this map that has been produced is maybe not as fair as would occur if partisanship wasn't being taken into account. So I think that's one of the primary uses for these sorts of algorithms that generate a bunch of maps. But there's others. This sort of same approach could be potentially useful with regard to race and redistricting as well. So Nick and Joey Chen have a paper where they randomly generate district maps and evaluate minority representation under sort of race-blind redistricting as compared to current approaches. And they're able to show that adopting a race-blind approach would significantly reduce minority representation in a bunch of different states. And so that's, again, making use of generating a target distribution of maps not subject to this particular criteria, and then showing how it compares to other maps. And then, I think another kind of intriguing and slightly scary element of algorithmic redistricting revolves around not trying to produce a target distribution of sort of maps not taking anything into account, but of finding extreme maps, searching for the most gerrymandered maps. There's been really pretty remarkable progress in generating algorithms that do this really well. And I've used these sorts of tools in my research where I've been trying to find what is the most gerrymandered map that you can draw, and compare to see what one party can do if they were sort of being most ruthless in gerrymandering versus how another party would do that. So, thanks.
Thanks, Ben. And to date, I haven't heard of any actual line drawers using algorithms in this way, for evil instead of for good. But it's clearly a potential use of the algorithms. Let's move on now to some of the redistricting lawsuits that are raging around the country. Some of these suits are in federal court, others are in state court. Some suits allege partisan gerrymandering, others involve race, and still others deal with state redistricting requirements like compactness or respect for political subdivisions. Mitchell, you're litigating a number of these ongoing cases. What are some of the highlights or the lowlights of the cases that you're working on? And what are you hoping that your cases will achieve?
Well, first off, I think that more legislatures need to read you and Joey's paper on how race-blind redistricting leads to bad outcomes for minority voters. Because there's this theory running through state legislatures that if they involve themselves in race-blind redistricting, then they can't be accused of racial gerrymandering, and they can't be accused of discriminating against minority voters. And that's just not true. Just because you ignore a fact, ignore racial and ethnic identities of voters does not mean that you are not being discriminatory against them. The Voting Rights Act requires minority voters to be protected, and you can't protect them if you're not looking at racial and ethnic data. And so that's one of the things that we hope comes from, one of the sub factors that we hope comes from our litigation is this theory that race-blind redistricting will absolve you of any judicial reprimand, and that's just not the case. North Carolina is a major example of that. In North Carolina, we brought a lawsuit against the legislature because they used a race-blind redistricting process, and under our state constitution that it is mandated under a case called Stevens v. Bartlett that they have to draw VRA districts first. And the only way you can draw VRA districts first before other districts is to look at racial data. And so in the past, the North Carolina legislature has been accused of racial gerrymandering and has found to be discriminatory against Black voters in North Carolina. And so they think that if they just stay in the middle of the road, that they can't be accused of being discriminatory, and that's just not the case. And we see that also in Texas. They also use the race-blind redistricting process. But if you look at the maps, the way that they crack to impact minority voters, whether it be Black, Latinx, or AAPI voters, the way they drew these lines, it was very race conscious, because the way you drew these lines, they were splitting communities of interest apart. as we noted in our complaint in that case. What we hope to gain from these cases, again, is a more equitable process, like the one in North Carolina, where we are challenging the process. We are not challenging the maps. We are challenging the process, because it's our theory that a flawed process will lead to flawed maps. And so that's the first thing. Is we want an equitable process, but we also want equitable maps. And we want to make sure that Black voters and Latinx voters and AAPI voters are being protected under the Voting Rights Act, under state constitutions, and we want to make sure that this race-blind theory of redistricting does not take hold and does not absolve, again, legislatures of that. And the last thing I want to note is that we see this race-blind theory in efforts to take back what the VRA has given Black voters. We see that being scraped back by local county commissions and states on the local level, in county commissioner districts and school board districts. Two examples are Lee County, North Carolina, and Caswell County, North Carolina. So in Lee County, North Carolina, there is a district in Lee County that was created from a Voting Rights Act case. And it's the only majority minority district in Lee County. But this year they chipped away about, I think, 6 percentage points, the minority population of that district. And it's still majority minority, but as they keep on chipping away at it, it will eventually not be majority minority. And that district was drawn specifically for as a result of the VRA case. And in Caswell County, there's this theory that that by drawing majority minority districts, you are diluting the voting power of white voters and Black voters. It's a very interesting theory that luckily the court struck down earlier this week. There was a case filed, and we intervened in that case and represented the county commission in Caswell County, or NAACP in Caswell County, and we're able to convince the court to dismiss this case because of this bogus theory that white voters are going to be, their voting powers diluted by drawing majority minority districts. And so that is just two examples that show what's happening right now.
Thanks, Mitchell. So it looks like North Carolina is going to maintain its status as probably the state in the country with the most redistricting litigation, which is a title that I think the state has had for decades. Kathy, I wonder if you could give us some more national perspective on the landscape of redistricting litigation. So which states do you see as the big trouble spots? And do you think litigation is going to help mitigate partisan gerrymandering or the elimination of competitive districts, both of which seem to be themes of the current cycle?
Yeah, it's a great question. And this is going to be the most litigious redistricting cycle to date. Like we ain't seen nothing yet. And so it's really going to be hard to find a state where there aren't lawsuits. For congressional and state legislative lines, All About Redistricting, which is a website that's was developed by Justin Levitt, but is currently being run by the University of Colorado Law School professor Doug Spencer, is tracking those in somewhat real time. So for folks who want to sort of follow what's happening. But there are sort of, in addition to the trouble spots in North Carolina and Texas that Michael referenced, you also have Alabama and Ohio, and we're expecting Georgia to join that group very soon. And most of these cases are either racial gerrymandering or voting rights challenges. And then there are the states like Minnesota, Virginia, Wisconsin, and Washington, where the courts are drawing or approving maps because that initial process, either by partisan commission or the state legislature, has failed to produce maps due to partisan gridlock. So the process defaults into approving those. And so there's just going to be a lot of lawsuits. And your question then about, well, what's it going to mean, right? It's sort of, well, the two states, North Carolina and Pennsylvania, the state courts have previously thrown out maps because of sort of these extreme partisan gerrymanders and the process. And we think that, there's an opportunity to slow that down. Unfortunately, there is no national standard right now, and not very many states have that written into their constitution. The one that does, that's kind of intriguing, is Ohio. That's sort of a convoluted process that goes to a commission, and then it goes back to the legislature if the commission fails to do anything. And it says that there has to be partisan fairness if the legislature passes those maps. And they made up this, it's sort of like, well, they've won 80% of the races over the decade. The Republicans have won 80% of the races over the last decade, so they should get 80% of the seats, and literally drew maps that reflect that, which was not at all, the intent of what anyone's sense of partisan fairness, right, of that translation. And so that court, that they passed their maps this fall. Those are already in the court, and there's a argument to be made that the court will take that up and make a decision, and people feel somewhat optimistic that the language was pretty clear in that constitutional amendment, and so those maps should be rejected, and then the court, their argument is the court should then impose new maps on that. The competitiveness is interesting because there aren't that many states that, except, and I think Colleen, Arizona, I think, is one of those, right, where competitiveness is a criteria. And competitiveness as a value isn't important to us, but competitiveness means accountability, right? If a race is going to be competitive, it means that the voters actually can have a say and can, either reward or punish politicians based on what they do when they're in office. And so it's the competitiveness isn't a criteria, so it's going to be hard to use that competitiveness as we get into the courts. And then I just really want to lift up what Michael was saying, that the local level is where we're seeing the biggest impact of the loss of Section 5. And Section 5 required that the Justice Department sign off on maps in advance of the final approval and those maps going into effect. It gave notice, right, that these things were happening. And so now, people across the previously covered jurisdictions are having to monitor literally every, right, it's one thing for congressional and state legislative, but for every county commission and city council and school board and sort of all those races. And then it also just shifts the burden, right? So it's not that they need to justify why they're doing this, but we need to prove how it's a racial gerrymander. And so there are, I think there are going to be a ton of lawsuits around the racial gerrymandering and the violations of the Voting Rights Act in those states. But it's a much heavier lift than it would be without the Section 5 of the Voting Rights Act.
Thanks, Kathy. So the last topic I want to cover is one that's already come up repeatedly, which is the Voting Rights Act and race and redistricting. So all district maps nationwide at every level have to comply with Section 2 of the Act, which often requires districts to be drawn where minority voters are able to elect their preferred candidates. At the same time, under the federal Constitution, it's presumptively unlawful for race to predominate in the drawing of districts. Colleen, you served on a commission that had to take into account multiple racial and ethnic groups in drawing district lines. And your commission also used the Voting Rights Act as a defense when it was sued for drawing districts with unequal populations. Can you talk about those experiences sort of in the trenches of Voting Rights Act compliance?
Absolutely. And kind of a fun fact, I don't know if the Ash Center / Harvard Law School planned this, but 6 years ago to this very day is when I was at the US Supreme Court hearing arguments in this exact case where we'll talk about, it's called Harris versus Arizona Independent Redistricting Commission. Yes, Arizona has a growing Latino population. We also have 22 federally recognized Native American tribes. So there is a diverse community. Population has actually been going down based on the most recent 2020 census. So these things all have to be factored into account as you're drawing these maps, of course. And the Voting Rights Act, our commission really focused on heavily because at the time is first subject to what's known as Section 5 of the Voting Rights Act. It was one of 9 fully covered jurisdictions, so we had to comply with pre-clearance when we drew the maps because it was pre-Shelby County. We spent a lot of time trying to figure that out, and the way we went about it was to hire a voting rights expert who knows this and had actually been working at the Department of Justice and on the receiving end of Arizona's submission 10 years earlier. So we thought, great, this guy knows what he's talking about and can give us great guidance. Some of that guidance that was given, and actually in public session, it wasn't an executive session, was to essentially underpopulate voting rights districts. So as you're drawing those districts on the legislative map, because there is some population deviation allowed in legislative districts, not on congressional districts, but legislative. And so we actually took that advice and did underpopulate majority minority districts in order to make them higher performing and strengthen them. And so, and that was a widely accepted strategy to use. And it ended up getting used against us in a case brought on our legislative district map. And so that one, they essentially said we had packed Republicans into the other districts. And so their voting power was diluted because of that packing. And in fact, because those districts were overpopulated compared to the underpopulated minority districts. Fortunately, the court ruled in our favor unanimously. So we won that case because there is population deviation allowed up to a 10% deviation overall in the map, plus or minus 5% ideal population by district. So we were, gratified by that decision. But that was 6 years ago today. But it was so surprising to get that lawsuit because we had just spent so much time, frankly, trying to ensure that we were going to pass pre-clearance on the first try. Arizona had never done it before in 30 years of trying, and even under Republican, administrations. And so it was, we were shocked, but gratified, frankly, that the court ruled the way they did.
Great, thanks, Colleen. Mitchell, you talked before about some of your cases that involve race-related claims. So one theory that's no longer available is that a district map violates Section 5 of the Voting Rights Act, which Colleen just mentioned, because the map reduces minority representation. And of course, the reason this theory is no longer available is that the Supreme Court effectively nullified Section 5 in the Shelby County case in 2013. So what has the impact of Shelby County been? In other words, how would things be different now if Section 5 were still available?
The impact of Shelby County has been swift. In the voter ID context, the day, hours after Shelby County came down, Texas passed, a voter ID bill that was found to be discriminatory, and North Carolina followed suit shortly thereafter. So it's been swift. And in the redistricting context, what Shelby County has allowed legislatures to do is to be emboldened to pass maps that may not pass constitutional muster and say, hey, catch me if you can. And they've gone so far as to say that, as that we don't have the legislatures have argued that they don't have the mandate to comply with the Voting Rights Act unless the court says they have to. And that is a very, very scary proposition, because it stands for the proposition that if nobody challenges this map, if nobody stands up against the legislature, then the legislature will have carte blanche to just run straight through and do whatever it wants to do. And that's where we at SCSJ and other organizations are standing in the gap and challenging and saying, hey, this is not right, this is unconstitutional, and we will challenge these maps, both at the congressional, state, and local levels. We will challenge all three, if necessary, to ensure that Black voters in particular and other minority voters are protected. And so this leads me to my second point, is that the Voting Rights Act of 1965 was passed in part because of this case-by-case adjudication. And so Congress passed the VRA to say, hey, we're going to put in an ex-ante preclearance provision that will protect voters and take some of the burden away from civil rights lawyers and other organizations from having to litigate these cases. with Shelby County, the floodgates open back up to where now we have to go case by case again. And I've often told my colleagues that it's like playing whack-a-mole. You know, you hit one and another one pops up, and you have to be really good at playing whack-a-mole in order to challenge all these maps. And that's why we need to pass federal legislation to reenact pre-clearance, such as the John Lewis Voting Rights Act, because that will be important. That was an important protection for Black voters. And now, if we pass it again, it will take away some of the, boldness that legislatures are now involved in passing maps and saying, again, catch me if you can.
Great, thanks, Mitchell. I want to move on now to questions from the audience, and apologies in advance because we've received several dozen questions, and so we certainly won't be able to get to all of them. So first off, overall, is the 2021 process better, worse, or more or less the same as 2011 from the point of view of producing fair maps? And I'll add here that there's a lot of evidence of the 2011 cycle, at least when it comes to congressional redistricting, featured the largest gerrymanders in modern American history, and also the most overall pro-Republican bias in the last 50 years or so. So are we seeing a repeat of 2011 or something different? And I'll leave it to the panelists to chime in as they see fit.
Nick, I'll answer at least with a little bit of a perspective that, as you were mentioning, 2011 was really about how the Republicans tried to do these extreme partisan gerrymanders, and their goal was to create as many Republican seats as possible. Some of what we're seeing right now is that they're no longer trying to increase those majorities. They're actually trying to solidify some of those existing seats, which has the impact of having fewer competitive seats. And that's a very stated goal of their at least national strategy. And it's hard because obviously we're starting with, in many states, these extreme gerrymanders. So it's not like we're not also seeing the same thing that happened 11 years ago. We're just now marking it in so that it can never get changed. And so I think and that is coming out with sort of as the parties are looking at who's realigning, they're trying to hedge their bets about what they think, both in terms of the demographic changes that will happen over the next 10 years in some of these states, but also how various like suburban voters might align with particular parties. So there's just a solidification of a lot of things happening out there, which I think will have the impact of not just locking in particular majorities in certain places, but also allow the more extreme aspects of either party to sort of have free reign in some of that, and thus make it harder for actual governing. And when we get into, particularly at the federal level, sort of close majorities, that there's not an overwhelming majority from one party or the other.
Thanks, Kathy. Anybody else want to chime in? If not, here's another question. So in this era of cell phones, social media, video conferencing, where a lot of people have very significant ties that are virtual, people far, far away from where they live, how much sense does it make to focus on geographically rooted redistricting criteria like compactness, respect for local political subdivisions, respect for geographic communities of interest? Do those matter as much if people's ties are now increasingly non-geographic?
Even I'll start on this one. I think it's important, regardless of technology and ability to talk with people halfway across the state or halfway across the country. I think the communities of interest and geographical redistricting principles are important, mainly on the local level. You look at your school boards, your boards of county commissioners, your other elected bodies on the local level. where you go to school doesn't, like, you go to school down the street, your kids go to school down the street, and the ability to what type of education they get at their schools matters. And unless you live in a state that you're able to send your kids, you have school choice, and you're able to send your kids across the city, who your representative is on the school board matters, and what policies they implement for your kids' schools. So that's one reason, is that on the local level, as well as I remember I'm being reminded of a small town in Georgia where there is a stark divide between the Black and white population, and the city council refused to do a lot of things for the Black community, such as putting a sidewalk in, or cutting the grass on the Black side of town. But as soon as I call what they call the white part of town, one of their tennis courts fixed, they fixed those tennis courts. And so, this keeping communities intact and ensuring that they are able to elect their candidates of choice is very, very important. And technology and your ability to talk to people doesn't really matter, because of the more local issues.
Thanks, Mitchell. Anybody else want to chime in? So here's another question. As Kathy mentioned earlier, the major congressional bills, so the Freedom to Vote Act, the For the People Act, they both tackle lots of issues beyond redistricting: ethics, campaign finance, voting ease in general. But there is a sense that one of the most urgent problems is the gerrymandering that's going on across the country right now. So would it be beneficial to split up these bills and try to enact a smaller bill focused exclusively on redistricting? Ben, I see you want to chime in first. I see you unmuted yourself.
Sure, I could take an initial stab at that. I mean, I think that just realistically, something like that is a plausible course of action. And ultimately, with a bill like HR1, I think first off, it seems unlikely to me that it will pass in any time too soon. But I think what it has done is it's laid out an agenda and sort of created a conversation around things like redistricting reform. So I think it's very plausible that some point down the road, when there is a majority in Congress of folks who support these sorts of reforms, that whether that be 2 years from now or 10 years from now or longer, that it could be that some of the parts of HR1 sort of are the starting point. And so it seems very plausible to me that any sort of reforms to the redistricting process could be part of a smaller bill that where you actually can get majorities in the House, which is not such an issue now, but also either a majority in the Senate or a supermajority, whatever happens to be needed at the time to pass it. So.
Thanks, Ben. Kathy, do you also want to, or Colleen?
Go ahead,
Okay.
Colleen.
Okay, I would just add that from a practicality standpoint, it may make sense to do that, to break it up. The only thing is, I would also say independent redistricting, we've seen this in Arizona, it only takes you so far. It doesn't cure all ills. There are other electoral forms that need to be packaged around it, whether that's ranked choice voting or top 2 or top 5 kinds of initiatives for primaries. So I can understand almost whoever was drafting HR1, the desire to want to, bring it all in. But from just a passage standpoint, I can understand also how you might need to break it out just to try to do this piecemeal in terms of getting things passed. But I just wanted to mention that independent redistricting, it's great, no question, but there, it has limits too.
Great. And Kathy, do you want to add something?
I think I'm just a teeny bit of the skeptic here. I mean, if you look at the redistricting commissions that have passed in the states, most of them have been passed because they went to the ballot, not because the legislature actually decided they wanted to give away that power. And so I think it's harder to get I think split. The reason it was included in a bill was because the sense was it would pass, it would be more likely to pass if it included a bunch of these other things. And so the question is, how do you sort of balance some of those? Like, what do people want? And then what can we, incorporate in that? But I think Colleen's point is right on. There are a ton of attacks on our democracy right now. And so we need to be thinking about what are the different pieces and how do we pass some of those? And then I think one of the byproducts of so much public engagement in the redistricting process this cycle is that there'll be a lot more engagement in trying to think about what are some of the reforms and what are the different voting methods, right? Whether it's ranked choice voting or in some of the southern states moving from at large to district, right? That can help address some of this malapportionment that happens in our electoral system because of redistricting.
Thanks, Kathy. So here's another question. Let's assume that quote unquote bad redistricting is in place in a given state, that there's a gerrymander that's been enacted. What strategies are available in that situation to voters and candidates who are targeted by the gerrymander? Is there anything they can do, or are they doomed to uncompetitive races and distorted representation?
That's a tough one. So one of the ways that you can challenge if you're in a bad gerrymander is, and this goes for states that have not undergone their redistricting process. So I'm thinking about Tennessee, for example, that has not undergone its actual official redistricting process. You can challenge the process by which the new maps are drawn. The advocacy is also a tool that can be used. We talked about communities of interest and keeping them together. So you can argue that the communities of interest need to be held together. You and your neighbors should be able to elect the same person if that is your candidate of choice. So advocacy can be a tool to kind of break the bad gerrymander. But also gathering and also in the advocacy process, and the litigator in me is like, let's find the smoking gun. Let's create a record for litigation that can be used to have a court intervene in the way maps are drawn, and maybe the maps will be drawn better with a special master, for example. So that's one way that a person can impact the process. If they're in a quote unquote bad gerrymander, is using the advocacy.
And I'd add, Michael, to that just exactly what you all are doing in North Carolina and what's happening in Georgia and in Florida, which is where people are skeptical that they're going to get good maps for the congressional and state legislative, but they feel like they have a real opportunity to get better representation at the local level. And the belief that sort of the community power building will really come from the grassroots up. So there's much more focus, not just because of the loss of Section 5 and the need to, but also the sense that this is part of how communities build power for the longer haul. And so I think that's also going to be, we'll be seeing that not just this year, but local redistricting will happen in 2022 and even in 2023.
Great. Let me get to one more question from the audience, which is, given the current composition of the Supreme Court, are majority minority districts soon to be a thing of the past? And I guess let me slightly rephrase the question. Are intentionally created minority opportunity districts soon to be a thing of the past?
I wouldn't say they're about to be a thing in the past because each state, as they redraw their districts, has to comply with Section 2 of the Voting Rights Act. And for the audience, just to note, Section 5 is a functional nullity, but Section 2 is still alive and well. And Section 2 talks about the opportunity to elect candidates of choice. That is the key part of Section 2 when it comes to redistricting. And so I think there's going to have to be some conversation about whether majority minority districts are the only way that minorities are able to elect their candidates of choice, or can we have coalition, what are known as coalition districts, where you have, for example, in Texas, you have Black, Latinx, and AAPI voters coming together to elect a candidate of choice. Some courts have recognized coalition districts, but and some have. But I think that's going to have to be a conversation of what does it mean to create a minority opportunity district, and does that mean that it has to be majority minority? There's a case, Bartley v. Strickland, that came down in 2009, which states that for there to be a opportunity district, it has to be 50% plus one. But it also mentioned that you can't destroy what are known as crossover districts, where there's less than 50% plus one majority minorities in that district. And so I think it's not going to be a thing of the past. I think we're going to have to change our thinking about what it means to have an opportunity district.
Thanks, Mitchell. Colleen, do you want to have the last word?
Sure. I agree. I don't think majority minority districts are going to go away because, frankly, the Voting Rights Act was reauthorized not that long ago, but by 100% essentially vote. Maybe it was 97-0 or something. And that's because, frankly, Republicans benefit from the Voting Rights Act too. When you draw majority minority districts, that only leaves so many Democrats, so to speak, to spread elsewhere in the state. And we experienced that in Arizona because, we do have this competitiveness criterion where you want to try to have some balance between Republicans and Democrats. But once you draw those voting rights districts, there's only so many left to distribute to make competitive districts. So, Republicans benefit from that too. They end up in safe seats, and we have that in Arizona, safe Republican seats.
Great. Thank you, Colleen. So we've now reached the end of our hour. So I want to thank the Ash Center for hosting this terrific event. I also want to thank our terrific panelists for their contributions, Mitchell Brown, Kathy Duval, Colleen Mathis, and Benjamin Schneer. And lastly, I want to thank all of our audience for attending today's event and for engaging so vigorously, offering us so many great questions. So thanks a lot to everyone for their participation today.